number 140, a matter of T-Mobile Northeast versus DeBellis. Good morning, counsel.
Good morning, Your Honors. John Nicolich representing T-Mobile. May I have 2 minutes for rebuttal, please?
You may, sir.
Okay, Your Honor, T-Mobile's rooftop antennas, base transceiver systems, and all other components of its transmission system equipment are not taxable real property.
What, under real property tax law, 102.12, Romanet I, what is included as taxable real property?
Okay, so when the legislature passed that statute, the legislative history indicates that long-distance carriers at the time, and we're talking about the 1985, 1987
Well,
period.
before we get to legislative history, don't we have to look at the words of the statute themselves?
That's right.
Okay, so what do the words say?
So lines, wires, poles, supports, and enclosures for electrical conductors. So we say that our equipment does not fall into those terms because there's also the caveat, the exclusion for station connections. So your question to me is what today, I believe, might fall into those terms.
Correct.
So the legislative history indicates that they were long-distance carriers at the time, such as MCI, that bypassed the local exchange carrier, so it appears that that type of equipment would be taxable. And we've also identified today cable television companies are not limited to providing cable television service. So, for example, you can buy telephone service from a cable television provider without getting cable television service. So those lines would not come within the exclusion, and it would be my understanding that then those lines and wires and poles that the cable television company used would clearly fall under this statute, as long as it wasn't being used to actually transmit television signals.
So it's your position that this statute only applies to cable television?
No, Your Honor, we don't know all the technology that is out there. We're limited to the record in this case as to T-Mobile's equipment. So there may be other telecommunications equipment.
if you put up a pole with a cell tower on top, cell tower equipment on top, is that a pole that is taxable?
A pole with
I drove past a whole bunch of them coming down here, big, tall, 30-foot, 40-foot tall poles that have cell equipment on top.
There you're talking about structures.
Is that a pole
And
under the statute?
I'm not sure that it would be a pole, but it may well be a support.
Wait, so
And
the 40-foot pole I drove by is not a pole?
if it's, I'm sorry, maybe we're talking about different things, but if
Yeah.
it's a pole or a structure, I believe
I mean,
in that
do you know
circumstance,
the kind of thing I'm talking about or not?
Excuse me?
Do you know the sort of device I'm talking about?
I've seen different types of devices like that along the highways. Some are poles, some are larger structures.
So let me ask you about that. If it's a straight pole that is just a single member, looks like a tree trunk, and it's 40 feet tall, and it's got a big kludge of cell things on top, is that a pole?
That's a pole.
Okay, and that's a taxable pole.
That's a taxable pole.
And if it's a different kind of structure that looks more like one of those electrical towers that has a lattice framework but has the same stuff on top, is that a pole?
I would say it's not a pole, but it may well be a structure. Remember a support, I'm sorry, the statute refers to supports.
Okay.
Okay? And
So those are taxable.
well, I would say, so for example, to make an analogy, buildings are used also as support for this equipment, but you don't take the position that buildings are not taxable. So in those circumstances that you've just identified, for these purposes on this record, I would agree that those particular structures you've identified would be taxable as not necessarily under 102.12I, but perhaps under 102.12B, which
Counsel-
refers to that type of
Counsel,
equipment.
so these two lines of questioning, the statute has terms within the plain text, and there are different structures out there that you can go and look at, and you can argue, is this a pole, is it a structure, what would you have us do? I mean, aren't those types of cases and that analysis more appropriate for a lower court or a taxing authority in some type of civil administrative proceeding to go onto the roof and look in the box and say, is it this, is it that? What rule would you have us change? What would you have us do in this case?
I think
Rather than go back and open the box and say, is it this, is it that, is it a structure, is it a pole?
I think
What's
it's-
the role of this court here?
Here, it's a straight matter of statutory construction. So, for example, Section 6 and 7 of Chapter 416 of 1987 laws very clearly indicate that telecommunications equipment and central office equipment are not to be taxable after December 31st, 1991. I think even my adversaries would agree with that. So, if this stuff is that type of equipment, it should not be subject to tax.
And that's
a straight
everything
matter
we're
of law.
talking about here falls
Well-
within that category.
Well, no, that's not exactly the
Right.
position we've taken. Because, so for example, the cables, the lines and cables, all right, there are lines and cables, but we say, wait a minute, they're not for electrical conductors as you construe the statute. But even if they are station connections under the uniform system of accounts and the type of regulations that were in effect back in 1985 and 1987 when the statute was passed. So that's as a matter of law. It's not a factual
Yeah, but
determination.
see, what I struggle with here is the question of the fixtures that are attached to the real property, and if those fixtures meet the common law standard for taxability. And so what I'm struggling with is I'd say, are these permanent fixtures or not? And how do you address that problem?
In two ways, Your Honor.
Go ahead.
Number one, as a general principle, this is 102.12I is a very specific statute addressed to telecom equipment, and therefore it overrides the general statute.
Yeah, but the underlying common law principles is a three-pronged test that we would apply. It seemed to still apply in 102I. Go ahead.
What, you're saying assume it applies?
Yeah, assume it
Okay.
applies.
So the other thing is, it doesn't meet the three-factor test because this equipment is swapped out from time to time.
How often?
Well, in the record that we have, it was done once for each of the,
Let me just
In
ask
a
this
period of
question, and
time.
I don't want to get you off it because it's a relatively complicated subject, but would we be required to make a factual determination that because of the nature of the equipment itself, it's moved, it's changed out so often that therefore it doesn't meet the requirements of 102I and therefore it's not taxable to rule in your favor?
I'm
In
sorry,
other words, will we be required to say, yeah, they change it out every 6 years, it's not permanent?
So that's under 102.12B. Yes, you would, I
Yes.
believe. But also, the second factor of the test identified in Metro Media and explained further in the Kaiser Woodcraft case is that it has to be applied to the use of the underlying realty. Now, in the Metro Media case, the sign frames that were there to generate revenue, and the underlying freeholder, which was the transit authority, was actually getting a portion of those revenues. So there, the freeholder, it was used for the purpose of the underlying realty to obtain revenues. That is not happening here from the use of the antennas and other equipment. We just pay lease rent, and the landlord value of his property comes from the rent. They do not get any portion of any revenues that might be attributable to the cell phone equipment. So therefore, it's not applied to the
So you're saying this would be
use of...
similar to taxing a tenant for a property tax, when in fact the landlord is the one who owns the property and has to pay the property?
Yes, the landlord is the property owner, and these are
Is
tenant...
that, do I have your argument right? Is that the quote?
Yes, and it's tenant leasehold improvements that no tenant pays when they go in and lease space and build out their office and put up partitions and things like that, or have other equipment that they use for their space, they don't get taxed on that property as real property.
Thank you, counsel. Counsel?
Good morning, Your Honors.
Good morning.
Tom Scapley from Ingham & Smith, attorneys for respondent, Mount Vernon City School District. T-Mobile has negotiated language into their lease agreements, which affords them the opportunity and the right to obtain a mortgage and title insurance on these installations. That language undeniably constitutes an admission that this installation is a fixture, it is not personal property, and it is intended to be a permanent addition to the freehold. When you look at that language, in light of the affidavit of their own expert who testified that their antennas are affixed to the parapet walls of the buildings with brackets, pipes. When you look at the photographs of these installations, there's steel I-beams everywhere. There are stealth shields. There are enclosures for electrical conductors.
But
or
are you
circuit
saying
breakers.
that's the sole requirement for a fixture, that the physical attachment?
No, I'm saying it's not. I'm saying that when you look at the cases and the precedent, the intention of the parties is really the predominant factor. And when you consider that they have multi-year leases, we're talking about 25-year leases, and they intend to make it a fixture by allowing them to get a mortgage and title insurance, I think that satisfies the tests.
What about subdivision I? Do you agree with your adversary as to the legislative intent of the 1987 amendments and as to how that applies to what is or is not covered in that section?
I don't. I don't agree with the petitioner appellant in this case. And I think when you look at 10212I, in order to accept the interpretation espoused by the petitioner appellant here, and in order to do so for the reasons that that petitioner appellant espouses, you would have to interpret the statute in a way that is inconsistent with an industry term of the statute. When we talk about enclosures for electrical conductors, we have industry manuals and we have court rulings which establish that an enclosure for an electrical conductor is a term of art in the industry. The petitioner appellant is asking this court to interpret that statute in a way which is inconsistent with the industry manuals and inconsistent with the industry terms and the way that equipment is identified in the industry. So I think I don't agree with petitioner appellant. I think.
So what happens if we interpret it the way you interpret it? Then what is covered by that section?
I think these installations on the roofs of these buildings are taxable property. They're lines, wires, poles, supports, and enclosures for electrical conductors. I think this is exactly the type of facility that the legislature
So could you
intended.
tax a homeowner for a DirecTV satellite that you put on?
Could I tax a homeowner?
Yeah, you tax a homeowner. I own my house, I put a DirecTV satellite on the roof. Can you tax me for that?
I think if it's intended to be in the cession to the freehold, then you could, but that's not what we're talking about here.
Well,
When you look at,
I'm carrying it out. I found with taxes, they multiply. We've all had that experience, so.
I think if you attach that antenna to your building with I-beams and with stealth shields and you hardwire it to the roof of your house with.
So in other words, the permanency of the attachment is one of the determinative factors.
Absolutely.
Would that fall under the station connection exemption or no?
I don't think it's a station connection, and again, I think that's one of the other fallacies in the petitioner's argument. I think if you interpret station connections in the manner espoused by the petitioner appellant here, it renders 10212I a nullity. If you accept their premise that everything on the customer side of the LECD mark is a station connection, then nothing can be taxable.
But a property owner gets taxed for their property, right?
That's
You're
true,
finished.
yes.
So they don't own the building, correct?
Correct.
Correct. So the building owner gets taxed for the property, the land, whatever they're going to tax, their ownership. I understood the statute to deal with exactly this kind of, frankly, very profitable relationship for both parties. And the tax is on them because they have ownership of the listed equipment. And that's what you're taxing, because the owner, I would think, if they destroyed this equipment, would be sued. Because it's not their equipment.
That's correct. When you look at the term station connection, the station connection is historically referred to as the equipment owned by the end user. So in the case where I have a station connection in my house, my computer, that is a computer used by me to connect me to the rest of the world. That is not what we're talking about in this installation. These cellular facilities are used to connect millions of people from here to these millions of people over here. So they're not end users, they're not station connections, as that term has been, is known in the industry.
Counsel, if we find that the property is not taxable under I, is there any other telecommunications equipment that would be taxable?
Is there any other that would be taxable?
Mhm.
I don't believe so, no.
Okay, thank you.
Thank you.
Thank you, Counsel.
Good morning, Michael Risman from Hudson Russ for the City of Mount Vernon.
Good morning.
Good morning. To me, this is a simple case that the petitioner is trying to complicate. The statute was amended in 1987 to tax this exact type of equipment. It excluded, the court asked what the intent of the law was. The intent of the law was to change the law, to change from ownership to fixtures-based rationale, and to exclude the central office, and to exclude customer equipment, and everything else in between was to be taxed. And this is everything else to be in between.
So part of their argument, at least as I understand it, I may misunderstand it, is that the stuff that is now sitting on the rooftops of buildings is functionally like what used to be in the central office of the old AT&T. And so they're looking at it not, their argument is, I think, based not on its location. They're saying location doesn't matter, it's the function that matters. And this is the kind of equipment in function that was excluded under the central office.
Well, I think not, Your Honor, I think the analysis is, when they changed the law, they wanted to change it to a fixtures-based analysis. The equipment that was in the central office was switching equipment, which was personal property, and those old desks and telephones that we used to have in our house, and the customer's property is personal property. But if you look at the record on appeal, it actually said that even some central office equipment under the new statute could be determined to be fixtures if it's permanently attached. So it didn't say no central office equipment. So I think it's really a matter of a fixtures analysis. And we keep this confusion about electrical enclosure for electrical conductors. There's a very simple analogy. Let's think about it, and it applies here. You think about a light bulb. A light bulb is just not light. It's an electric signal that becomes light. And actually in the Chautauqua County case that I've attached to the decision from the lower court, we learned that this works. It's an electrical signal becomes a light, and then to get it, move it down the conduit, it has to be amplified with electric again. It becomes electric, light, and then electric at the end. So when this language about enclosure for electrical conductors, that wasn't meant to change this or undermine the entire statute. It just reflects that it's the energy that drives this. And enclosures for electrical conductors, if you look at our expert's affidavit or if you look at their expert's affidavit, it talks about electrical equipment within enclosed racks and cabinets. How can we say an enclosure with electrical equipment is not an enclosure for electrical conductors?
I mean, the sentence does make a distinction between electrical and electromagnetic, and light would be electromagnetic but not electrical. Would you agree with that?
Well, I just think that they're interrelated.
Well, they are.
You know, the light,
One's a subset of
the
the
electric, and the cable, the other big picture, I think, issue to think about is why is cable out? The cable is out for cable company for one particular reason. They're treated differently under both New York State Public Service Law and under the Federal Telecommunications Act. They have a franchise fee, they pay 5% gross sales revenue. So it's not like the cable companies are not getting taxed. They're getting taxed in a different manner. So, you know, that's an entirely different situation than the cable company in my mind. In terms of fixtures, I agree with my co-counsel. If you look at those leases, those are long-term leases. These are not your antennas that my father used to go to the hardware store. They're not like a single pole you just throw up there. If you look at, I think it's page 312 of the record, there's an interesting picture of this. The court ruled that the antenna was not a pole because it said it was an enclosure for electrical conductors. And I was wondering, well, why did they say that? Why didn't they just say pole? But if you look at the picture on page 312 of the record, it has a antenna that's 5 feet high, 2 feet wide, 2 feet deep, 4 feet wide. And it has electrical lines, it looks like, coming into it.
Is it a wire?
It's an enclosure for...
No, the antenna itself. Is the antenna a wire? Is that a reasonable?
No, it's a structure. It's 5 feet high by 2 feet deep by 4 feet wide. And they're so big, they have to put stealth shills over it to not upset the neighbors, because these are very nice apartment buildings. So if you look at it, you see why the court said not your normal. Normally, I would have said pole antenna, but it's not that same antenna. If you look at the antenna structures, and that they may upgrade it once in a while during this 25-year term, doesn't mean it's not a permanent installation. They're not meant to be.
Counsel, in your brief, you, after defending the AD on the merits, you advanced a procedural argument. Am I right to conclude that if we were to go your way and affirm the AD, that your first choice would be that we affirm on the merits argument, and that you've advanced the procedural argument as an alternative ground for affirmance?
Absolutely. I'd like you to resolve the merits of it. And I feel that this is not a close question in my mind. If you look at the case law, Nextel, VoiceStream, Judge Case, Judge Gerasti, the Second Department, the only case they cite, that RCN case, 5 months later, if you read the second to last paragraph of the second RCN case, they specifically reject petitioner's interpretation. So the only authority they have is a First Department case that the First Department actually overruled or explained.
Thank you, counsel. Mr. Nicolay?
Yes, Your Honor, there's a couple of brief points. Mr. Rissman referred to the legislature adopting a fixtures-based analysis back in 1987, and the support for that is an internal SBEA memorandum that was their own view of what this legislation was. But if you look at the legislative history, they actually proposed legislation with language that would have made central office equipment taxable if it qualified as a fixture. And the legislature did not accept that proposal. So to my mind, Your Honor, that means that any central office equipment is not going to be taxable even if it would qualify as a fixture. So the fixtures-based analysis just does not make sense, and it would indicate that the legislature passed legislation in 1987 specifically making...
Well, wouldn't that perhaps only suggest that you make a decision on a fixture on a case-by-case basis based on the facts?
I don't think so.
As opposed to all equipment falling within that particular classification?
Yes, if the legislature comes out and basically says central office equipment and switching and transmission equipment is not going to be taxable, and then lets the taxing authorities backdoor it by using another
Well, it
provision
doesn't
of the
say
statute.
that. Your point is that someone proposed particular language in the legislation. You don't find it in the legislation. My only question was, might that just mean that as a broad classification, the legislature didn't adopt that view, but that doesn't prevent an individual case-by-case analysis?
Your Honor, given the legislative reports that the legislature commissioned here and everything said about central office equipment, I don't think that the legislature contemplated that at all. Mr. Scopoli referred to an industry manual about what equipment for electrical conductors is. That is not anywhere in the record, but what is in the record is SBA report indicating when they refer to this type of statute, they refer to lines, wires, poles, and conduit. And the ORPS report that Mount Vernon has cited also refers in several pages to lines, wires, poles, and conduit. So it's not limited to this electrical box that respondents are referring to. It's really a much broader term, and when you apply that term the way the Second Department has construed the statute, it means that conduit for fiber optic cables would not be taxable, but conduit for coaxial cable would. It makes absolutely no sense, and I ask you not to reach that absurd result. Thank you.
Thank you, counsel.